Good morning, everyone, and welcome to the first installment of a new series from Brooklyn Law School on law in time of crisis. I am Michael Cahill. I'm the Dean of Brooklyn Law School, and this will be the first of a series of conversations about how legal issues arise during times of crisis. And obviously, we are currently in what is most directly a health crisis, but we're going to be talking about various kinds of issues that surround all manner of different crises that relate to the health crisis and might be adjacent to it. So we are going to be discussing how times of crisis give rise to legal issues, sometimes expose flaws or pressure points in the law as it exists, and possibly create opportunities for legal avenues to remedy the problems that we face. And to have our first conversation in that series, I'm very pleased to be joined today by Robin Effron, Professor of Law here at Brooklyn Law School and co-director of our Dennis Block Center for the Study of International Business Law. Robin is the perfect person to talk about confession of judgment clauses because she teaches civil procedure as well as international business law courses here at the law school. And she recently published an op-ed about confession of judgment clauses, today's topic, in the New York Law Journal. Robin, welcome. Great to have you with us. Maybe we can start off just by briefly explaining what these clauses are.
So these are clauses in contracts for primarily loaning money, and they are called either Cognovit notes or confession of judgment clauses. You see both used. And what they are a clause in a contract, in a debt contract, that says if there is an event of a particular type of non-payment, which usually just amounts to a non-payment of the debt after a certain amount of time, then the creditor can go to court and take with them the evidence of non-payment, as well as a copy of this contract that you have signed, and say, this person has agreed to just have judgment entered against them. So they have agreed to give up their right to everything that we would normally expect in a lawsuit. But in this situation, none of that happens, right? What happens is that the plaintiff goes to court and the court enters judgment on behalf of the plaintiff, right, having looked at these documents, and the defendant never knows. And typically the first time that the defendant finds out that a lawsuit has even been filed is when the plaintiff goes to enforce that judgment. And the way that judgments like this are enforced are that you get a court order that will freeze the assets, right? So what will happen is that somebody will go to their bank account and find that their assets have been frozen. Or sometimes when it comes to seizing physical property, like real property or personal property, somebody will find out because a sheriff or a repo man, as it were, shows up and takes your vehicle, right, or seizes part of your real property.
So it sounds from your description like the way these clauses work is that the borrower is almost literally signing their rights away at the time they enter into the loan and saying, if the day comes when I don't pay you, you will be able to get a judgment against me without my opportunity to be heard in court. Is that basically the way these things operate?
Yeah, I mean, that's what it is. And it's a tricky area of law, right? The question of when people can sign their rights away. Because, you know, if you think about it, it is possible to sign your rights away, right? There's all sorts of constitutional rights that, you know, we can talk about even in other areas where there's a question of whether people are allowed to give up those rights in exchange for some other benefit or service or money. But these are particular procedural rights, and this is a somewhat contentious area of law. So for example, there are other things that we might wonder, like can somebody give up their right to a jury trial in a contract, right? And that's a somewhat complicated question. But this one, I think, really is sort of a special right that we should be particularly concerned about, because in some sense, it is the original right from which all of the others are made possible, right? Which is that if you don't hear about a lawsuit, none of these other things can happen, right? So I tend to think that this is a special due process issue, right? That when we as commentators or lawyers or lawmakers think about when it's appropriate for people to be able to sign away their rights, that this is one where I think that due process right should matter more. And in fact, I am not alone in thinking this, right? So I already mentioned that this is a particular type of thing that only happens in so-called commercial transactions. So it has already been determined by all 50 states that no consumer could enter into this type of contract, right? So if I were to go and get, say, a loan to buy a car, it couldn't contain one of these clauses. That would be void as unconscionable or void as a matter of public policy in all 50 states. So I think, the fact that we have this patchwork across the US already shows like how seriously this is taken.
And the same person in the consumer context who'd be getting a car loan is the person who's running the nail salon or the pizza parlor, and they're not any more sophisticated in that context potentially than they would be.
Exactly, right. And you might have a lawyer that is looking over this contract with you, or you might not, right? It depends. And if you think, just to sort of extend the car metaphor a little bit, right? This is a situation in which somebody still could have a vehicle taken away. So let's say that you own a small flower shop and you deliver flowers, or you are a dry cleaner and you deliver dry cleaning, and you have a vehicle for that business, but it's also your only vehicle. It's the vehicle that you also use in your daily life, right? If that vehicle is tied up with the business, right, and it's tied up with that loan in some way, or it's just an asset that belongs to the business and doesn't belong to you, that means that, the business's car could be taken away. But what the actual business owner experiences, I have no car anymore, right? My car has been taken away. Now, what's interesting is that, in the United States, at both the federal and the state level, we've had, a long history in the last 100 years of sort of confronting and reconfronting those issues, right? That, we create one set of rules about either limits on interest or types of interest, or more commonly, we are interested in transparency, right? That's tended to be the answer, right? Well, we're not going to sort of completely shut down every last practice, but we're going to at least mandate disclosure. Another big one is the equal opportunity ideas, right? That banks and lenders are not supposed to be charging different interest rates, and namely higher interest rates to people just because they are coming from minority communities. Don't forget that it was as recent as the 1970s that women couldn't take out a credit card in their own name, right? They had to get permission from their husbands. So, a lot of these differentiated practices are not that far back in our history. So, what's happened here is that this has always been possible. And I think, as we tighten up some of these other regulations, there are always going to be some of the smaller lenders who see themselves as filling the space in the market for smaller businesses, or, businesses that don't have the sort of collateral available to get more traditional loans, or for other reasons don't qualify, and say, here, I'm going to lend you the money that you might not be lending otherwise, right? And here's where, I will give you the defense of confession of judgment clauses, which is that they make it cheaper for the lender to lend money, right? Which is to say, if I loan you money and I know that I'm going to get repaid one way or another, right? Either you're going to make your monthly payments to me, or I am going to have immediate and uncontested access to your assets, which may or may not satisfy the loan, but they're going to be something, right? Then I'm going to loan you this money, right? And that's the argument for having these clauses, which is, especially when it comes to businesses, shouldn't we let people make this decision, right? Is this not freeing up money for people that wouldn't otherwise be available? Because now we're going to have people sort of filling that market gap and lending money where they wouldn't be lending it otherwise.
Or reducing the rate when they do lend, right? So presumably the risk goes down, and therefore the interest rate needed to make the loan profitable goes down.
These are just sort of unfair by their own terms, right? That it is sort of uniquely onerous to put someone or their business in a position where their assets will be seized without the ability to contest it. And that sort of bleeds into the public policy. So public policy is a different ground for saying that a contract is void, right? And so, some of the classic examples of contracts that are void for public policy are, contracts to buy or sell something that is illegal, like illicit drugs, or, you can't make a murder for hire contract. We can't put a hit on somebody. It's illegal to kill, right? So it's illegal to make a contract to kill, right? But in public policy, there's a lot with less dramatic examples, and this is one of them. And some of the states that have come to this conclusion, either through their courts or through their legislatures, which have prohibited these, have said, quite aside from the unconscionability issues, our public policy values there being notice and opportunity to be heard when there is a public legal proceeding, right? That is an important public value. And it's a value that these states wish to preserve, quite apart from whether or not you could point to one contract and say, well, they were sophisticated parties, or these people knew, so they were okay, right? They're gonna say the value of openness and the value of notice and opportunity to be heard, that is in itself an important enough public policy that we're going to ban these across the board. And so, one of the avenues, right? I don't think that people are going to have a ton of success making direct due process challenges to federal courts here. I just don't see that as, for better or worse, the direction that the law is going, even though I personally think that the due process argument is strong. But I do think that if people went to their state legislatures, right, and asked for these sort of remedies, right, to say, please make these illegal, that is something that state legislatures are completely capable of doing. You don't have to wait for state courts to decide that these are unconscionable or void for public policy. You don't have to wait for a federal court to decide that it's a violation of due process. You can just ask a state legislature to do what a lot of other state legislatures have done, which is to outlaw these sorts of contracts, right? And that's where I think there's good news at the federal level, which is that there's no federal statutory authority that's going to come in and preempt that. And certainly, while the due process clause isn't in a place right now where it's giving the most protection that we'd want to give, it's definitely not out there stopping people from having these sort of legislative fixes at the state level. This has been with us for a while, but it's only started to take off as a big business in the last 10 to 20 years. And so I think that there's a little bit of a lag in terms of seeing the problems, right? And we've hardly even touched on this issue of the current crisis or a crisis in general. But the reason that I, thought about this particularly in relationship to the crisis we're in now is that everybody is worried about small businesses being impacted and shutting down and being unable to meet their obligations. And so my worry is that, in so-called normal times, you're always going to have that run of small businesses that are unable to meet their obligations, and then they're going to sort of end up having their assets seized and being victims of these confession of judgment clauses. The worry is now is that it's not just some businesses that are unable to meet their obligations, but it's so many more than we would normally be seeing, that I think that might sort of reveal just how many businesses actually have these confession of judgment clauses in their contracts, right? Businesses that ordinarily would never have known this was going to happen because they were doing fine and they were paying their loans and everything was great.
Well, it's a fitting way to wrap up our first conversation in this series about law in time of crisis, and also to sort of kick off the series by pointing to an issue that was always there and always significant, but certainly will be foregrounded or spotlighted more in the particular context we find ourselves in, where more people are going to be perhaps in the situation of defaulting on their loans and having these clauses take effect and feeling their impact in a way that we might not have noticed before. So many thanks, Professor Robin Effron.
Thank you.
for joining us for this first conversation. Thanks to everyone for watching, and stay tuned and be on the lookout for further conversations in our new series on law in time of crisis. We'll be back soon. Thank you.